Hello. Hello. Nilima ma'am. Good morning.
Hello.
Audible?
Yes, sir.
Okay, ma'am. Thank you. Hello, ma'am.
Hello.
Can you please turn on camera? It's a blank screen. Ma'am is still blank screen, so please.
Yes, I'll just try to
Okay.
camera on.
Thank you.
Hello, sir. Hello, sir.
Hello, audible. Okay.
Hello.
Hi.
Hello. Nice to see you.
Nice to meet you.
Good morning, everyone. With a great pride and excitement, I warmly welcome all of you to the day 2 of ICAST 2026. So let us begin our technical sessions. First of all, I kindly request Dr. Reina Jose, Associate Professor of Department of Chemistry, to introduce Dr. Nilima Pradeep, CKT College, Maharashtra.
Dr. Nilima is Associate Professor, Department of Microbiology. CK Thakur, Arts and Science College, New Panvel. She has 2 patents, AI-based biosensor device for enzyme detection, AI-based crop disease detection device. She has got numerous number of publications. and she has got her book published the international book as author and as editor. Then she has got pretty much projects in her credit. Biodegradation of feather waste using keratinolytic organisms and its application in hydrolysis of gelatin layers and release of silver particles from used X-rays. Then many projects are there, almost 5-6 projects she has completed. And more than that, she is the associated NCC officer of her college. So that is how our friendship started. So welcome, Nilima. Let's start the session now.
Yeah, thank you. Um, First of all, I would like to express my sincere gratitude to the college for inviting me and serving me as a guest speaker for this international conference. The theme of this conference is Advances in Science and Technology. It's really privilege for me to deliver a talk in front of such a lovely audience here. And thanks, Rena ma'am, for introducing me and introducing for this session. Now, basically, I'm a faculty from science background, that is life sciences, and my specialization is in the field of microbiology. So I have done my research in microbiology and also done all the projects and patents related to microbiology. I know this is a conference related to chemical sciences, but I hope the topic which I'll be covering here, it is a topic that is common to all the science field faculties. So therefore, it will be an interesting topic for all of you. Initially, I'll be discussing about the basics related to innovations, then IP, that is intellectual properties, the different types of IPs, as well as I'll be mainly focusing on the patents. And I'll be also discussing about the patent which is being granted to me, which is a work of my PhD itself. So I'll begin with my presentation. Ma'am, can I share my screen?
Yes, ma'am, you can.
Yeah.
Please. Thank you.
Thank you. I think I'm not having the access of sharing the screen, I guess.
Ma'am, just wait. I will check that. Ma'am, actually, you can share the screen. The permissions are allotted. Nilima, ma'am, you can share the screen.
Okay.
ഒരു മിനിറ്റ്. പിന്നെ ഇതിൽ ma'am, Nilima ma'am, the screen presenting is visible, so you can start the conference.
Yeah. One sec, sir. I'll be just sharing it in some time. Sorry for the delay. Hello, sir. Is my presentation visible now?
Yeah, ma'am, it's visible.
Okay.
Okay, thank you.
Okay, very good morning to all of you who have been present here. Good morning to all the organizing team members. The topic which I'm going to present out over here, it is on innovations, intellectual property rights, as well as patents. And I'll be focusing on patents in detail. So let's begin with the presentation now. And sorry, I'm extremely sorry for the delay and for the problems which I faced for opening my presentations. And thank you for your patience. Now, to begin with, we all are familiar that innovations are nothing but the new ideas, products, or process that we need to keep on actually present, that we need to keep on innovating it, right? Innovations is also necessary because it helps in transforming the knowledge into practical solutions. It also adds values to the society and also to the industry, and therefore there is a need to constantly go on towards innovation. Now, innovation is not only in the field of science, but innovation it can be to any field, and innovation is a need and must in present society. Now, if you see the importance of innovations actually it is helpful for us for driving the economic growth. It helps us to stabilize the economic growth of the country. It helps us to improve the quality of life. For example, many of the innovations we all know, refrigerator, telephone, then the televisions, they definitely are adding improvement to the quality of our life. Similarly, in the earlier cases, there were no vehicles which were being available. We used to travel through bullock carts and all such things. So hence we can say in all aspects, this innovations, it can improve the quality of the life in all senses. Definitely, innovations will also enhance the global competitiveness, because if you are constantly into the field of innovation, definitely it will add up to the new benefits to the country, and we will be able to stand competent with the other countries. And definitely, innovations can solve the real world problems. So, as per the theme, which is innovations in the field of science and technology, so I think innovations are very, very important to us, and we should constantly go towards innovating new ideas so that we will be competent and stand ahead in our life. Now, if you talk about innovations, innovations are basically nothing but your intellectual basis, and this intellectual basis or your ideas, which are your creativity, which are your intangible properties and all. So if these innovations are not being protected, okay, so definitely your ideas will be copied by any random person, and they can claim that particular idea as their own. So therefore there was a need to actually frame certain rules and obligations to the ideas which have been put forth by mankind, and the IP or intellectual property came into existence. Now, this describes very well about what does intellectual property means. So, intellectual properties are nothing but the intangible properties. So, you all can see the books, the invention of the bulb, or we can say phone pay. These are all the concepts or ideas which came into the ideas from the mankind. So, therefore, they are considered to be as the intellectual property. And those properties which we normally own, for example a house or a car, that is called as a tangible property that you can see actually and that you can claim. But many of the times it happens that the ideas which we actually come up with, or the concept that we actually talk about for, we do not claim for us. So therefore the Intellectual Property Act was being framed in 1970, and so that the person who holds this particular idea could be given an intellectual property rule that in the form of patents or copyrights and all, so that that person can claim that particular idea as its own. So this is how the IP came into existence. And to protect this particular intellectual property, the concept of IP was very, very important, and it all started about. Now, like we own the property, and that property is our own obligation. Similar way, according to the Intellectual Property Act or rights, it imparts legal rights to the creator who owned this idea and the concept which he actually put forth in the field of innovation. Now, intellectual property is also very much needed to protect or prevent the unauthorized rules and unauthorized use of our ideas, to ensure the recognition of the creators. And intellectual property is also needed because it encourages investments in the field of research and development. Now, if you basically focus on the intellectual property, which we said it to be as an intangible form of property, it can be distributed into different forms of criterias. So here we can see the intellectual property, it has been distributed into industrial property related rights, that is patents, designs, trademarks, geographical indications, and also copyright related ideas. So all this basically is put forth into intellectual property, and each and every intellectual property, it has its own act, it has its own rule, it has its own tenure, and based on that we can claim this particular intellectual property as its own. So thus when we say a property, it can be it can be basically divided into tangible as well as the intangible form of property. The tangible form of property is the one that we actually can look around with, we can claim, we can say that this is owned by us, for example a moving car or a building or a house. But intellectual property is the one which is intangible, which we cannot show to anyone, and therefore to claim this particular property there is a need of framing an intellectual property rules and laws. And based on that, the IP rule came into existence, and in this particular IP concept, the patents, design, trademarks, geographical indications, and copyrights came into existence. So I will try to describe this intellectual property into details, and then we will focus on the patents, which is the main theme of my presentation. So copyright, we all know that there are new poems which are being created. Then there is literacy work in the form of novels. There are plays, newspaper clippings, articles. So all this which does be protected, and it will be not claimed by any other person to be as their own. Then to go further ahead, this copyright tenure in case of India, that means from country to country, the tenure of this particular copyright, it keeps on varying. In case of Indian locality, the copyright tenure is for 60 years. And for other countries, it can extend to 70 years, 50 years, and so on. So we'll try to focus on the Indian terms and conditions of copyright. And suppose if you get a copyright, the tenure, it lasts for 60 years. Then further moving ahead, the trademark, it is again another form of the intellectual property. Now we all know about the brands of Adidas shoes, then the Coca-Cola, which you normally go for drinking every day, the logo of Coca-Cola. That means trademark basically focuses on the brand or the logos. Now BMW, the car BMW. Then in the case of the logo of Nokia and Hero Honda comes ka M. So this cannot be copied by any other in any other industry. So this M logo, from far also we can see this particular logo, and we can make it out that yes, there is a McDonald's which has been there in the nearby area, and just on the basis of the logo we assigned what the type of hotel or what the type of that firm it can be. So this logo basically can be protected with the help of the IP, and the IP which protects this particular logo is called as a trademark. So therefore, if you design any symbol, or if you design any monogram, or if you design any particular type of a logo, and if you want that logo to be protected, it should not be copied by any other firm or industry, then immediately you have to go for protecting it by terms and conditions of the intellectual property. And under the term of trademark, your logo or your brand or your design, it might get protected. So therefore, this will not be copied by any other firm, and you retain this particular criteria of your firm itself. So this is very, very important from industrial point of view, because there can be a chances that in other industries, there is lots amount of duplications in the field of competition, and there can be a possibility that different types of industry can copy down the same type of the logo and sell to the customers in a commercially low prices. So this will affect the overall consumer production, or we can say the sale of that particular company. And for this particular basis, it is very important for the company to protect its trademark or the logo, or we can say the brand. So on the basis of the brand, we can decide, yes, that this is a logo, that means it has to be an Adidas brand. If this is M logo, that means it has to be a McDonald's. So it is a representative of that company. So therefore, this intellectual property of a particular company, it has been protected in the form of a trademark. Now, the duration for this particular trademark, that means once you get the trademark for a company, definitely the tenure for this particular trademark, it extends up to 10 years. And after 10 years, you have to go for carrying out renewation of this particular trademark. If suppose you don't go for carrying out its renewal, it will be copied by any other firm and they can use it as their own. So therefore, after every 10 years period, it is very important to go for carrying out the renewal of this particular trademark by the company, by again carrying out the filling of various forms and monetization in order to keep the trademark for their company itself. Then the next is industrial designs. Now we all know that there are characteristic shapes and designs which have been allocated by various industries. For example, the typical size of the bottle of Coca-Cola. Then similarly, some jewelry designs which are being owned by some renowned jewelers. The shape of the shoes and all. So this is called as the industrial design. And this is also the design which is being owned by the industry. So therefore, this is also, we can say, or considered to be as an intellectual property. And if you want to protect this particular intellectual property, then again, you have to fill in the forms and obligations, and you can own this particular intellectual property as your own, right? So the tenure for this particular intellectual property, if you own in the form of industrial design, it will be for 10 years. After 10 years, you have to go for again extension or renewal. So therefore, industrial design, we can say that any three-dimensional shape hai, surface ka texture hai, or for example, any visual form of a product, or we can say any ornamental or useful article of an industry, or any product attractive or appealing to the consumers. The design that we actually make, it all comes under the intellectual property under the heading of industrial design. To further go ahead, very important and very familiar, we all are about the geographical indications. That means every region of the country is peculiar for its own vegetation, or we can say of their own products. We are all aware of the Tirupati laddus, then the Darjeeling tea. When we say tea, the first thing that comes into our mind is Darjeeling tea. Then again, there are different bands or a size of chappals which are usually sold in Kolhapur in Maharashtra. So there is a unique location. Every location, it is peculiar for their own product. And therefore, the government says that that location wise, that product has to be named and it has to be protected so that that location gets its name fire apart. So similarly, basmati rice, then Darjeeling tea, and all this intellectual property, it comes under geographical indications. And this also we can protect it, so that therefore no one can claim that oranges bolat, it has to be Nagpur ka oranges from Maharashtra, or the silk sarees, we can say, the silk sarees and all. So these all are familiar with regard to a particular locality. And therefore, this the locality, the region-wise familiarization has to be protected, and this is protected under the intellectual property, that is geographical indication. Again, the tenure for this particular geographical indication is only for 10 years, and again, after 10 years, you have to go for carrying out its renewal. Then to further go ahead, the trade secrets. Trade secrets means a particular, now see, every time when you visit McDonald's, you get the same taste of the burgers. If you visit the coffee shop, then if it is of a particular brand, you get the same taste of the coffee, right? So any confidential business information or any recipe or any formulations, it all comes under trade secret. So every company tries to keep its trade secret confidential, so that that recipe, that formula, that confidential business process, it has been owned by that company itself, and no one else can copy that particular thing. So this formulations, or we can say this type of protection of the IP, it comes under trade secret. So thus we can see over here that the formulations, or we can say the typical taste of Coca-Cola, it comes under the trade secrets. So if you see this, so let's imagine all the intellectual property into this one bottle size. So the logo of Coca-Cola, it comes under trademark. Okay. The typical design of the bottle of the Coca-Cola, it will come under protecting the intellectual property in the form of industrial design. And if you own the equipment of this particular of this bottle, then this IP, it will be protected in the form of a patent. And if you quote something, the jingles or any particular logo, or we can say, that comes under copyright. So here you can have a blend of all the IPs together. So this is how the IPs in the form of trademark, industrial design, patent, copyrights, it can be protected. And every industry, if it goes for carrying out this particular process, definitely they will be able to protect their intellectual property by owning the property of their own in the form of trademark, industrial design, patents, copyrights, and so on. Now, if we see around the different types of intellectual properties, we will be now describing the patents now. But list of all the properties we have at present listed, and we have seen that. So trademark, design, copyright, and geographical indication. So trademark, after 10 years, you have to keep on renewing it. A trademark, it was implemented in the year 1999. Then it was amended in the year 2002. Similarly, the Design Act of Intellectual Property, it was implemented in 2000, and later on the rules and obligations are being amended every time. And now we follow the same copyright act. It was being implemented in the year 2004. Copyright, it was being implemented in the year 1995, and according to the same Copyright Act, we are following the rules and obligations which are being laid by the Indian jurisdiction scenario. The Geographical Indication Act, it was being registered for protecting the geographical indication goods, and it was in the year 1999, and henceforth we are implementing the same act. Now, if you see the tenure of different intellectual property, if you go for trademark, you will get the trademark lifelong, but after 10 years, you have to keep on renewing. For design, the maximum protection you can up to 10 years, and after 10 years, you have to keep on renewing. Similarly, the copyrights, it is for 16. That means once you get the Copyright Act, it requirement of renovation. For lifetime, you will have that particular intellectual property owned by your owns. Similarly, the geographical indication, it will be also for lifelong, but only after 10 years, you have to go for renewal. Now, the first one, that is patent, which we are basically going to focus on. So patents are nothing but the exclusive right for the invention. It is the patent are being granted for a product, or it can be granted for a process. Patents require full public disclosure. Patents are very, very important for commercial advantage in the field of technology transfer, and also in the field of research and development. I hope I'm audible. Hello.
Yes, ma'am.
Yeah. Thank you. Now, who can go for carrying out, or who can go for proceeding towards registration of patents? Now, everyone, see, registering for patent is not something, rocket science. Everyone who has a novel idea, it is a new invention, it has not been disclosed or discovered by anyone earlier, then that person can go for filing a patent. Now, so if you want to file a patent, definitely your concept, it should have three important characteristic criterias. First is it should be novel, that is, it should not be invented by any other person. It should be your own concept, your own idea. Then similarly, the invention should not be obvious. That means, and it should have some industrial applicability. If the invention that you're doing is, if it is not having any type of industrial applicability, your patent will not be granted. So therefore, there should be some concern, there should be some benefit to the locality, or the patent, you can file a patent of a particular product or a process which is not going to harm to the environment in any scenario. So anything that is going to harm to the environment, that process or the product will not be patented. So this criteria have to be thought in the mind. Ki if you want to, if you think that your idea is novel, if you think that you have come up with a different type of innovative findings, and that is not being related to any other rules, any others concept, and this your process or your product is not going to harm to the environment in any scenario, then yes, you are the one who can proceed ahead to go for filing a patent. Now, if you file a patent, the tenure for the patent, it's generally for 20 years. After 20 years, you have to keep on carrying out the renewal. Now, the person who files a patent and gets a patent, definitely he will get a right to make use of that particular innovation. That license related to that patent will be owned by that person, and anyone who misuses this particular patent, you can claim a rule of infringement against that person, against legal rules and obligations. So these are the various amendments, or we can say act, which were being progressed ahead, and these were being laid by the government of India. The Act of Patent, it was being laid in the year 1970. Few amendments are every time they are been happening to make it more user friendly, and to see that there is no infringement or no one copies your ideas in future and claims as their own. So therefore, the refrainment, or we can say the amendments of different rules are being done every time, and now we actually follow the implementation rule or drafts, which has been amended in the year 2008. Now, there are only four patent office all over India, and they are being governed by the Patent Acts according to 1970, which has been further amended in 1999, 2002, and now we follow the 2005 Act. So these are the four offices which are located in the major cities of the country. That is in Mumbai, then one in Chennai, the other in New Delhi, and the fourth one in Kolkata. So these are the four legal offices from where we can follow the criterias for filing the patent. Now, who can file a patent? As I've said, anyone, if you have come across, even a 15-year child can file a patent if its innovation is novel one. So there's no such criteria. Any person can file a patent as far as the idea has novelty and it is not going to harm in any case to the surrounding. So therefore, any inventor, any assignee, or a legal representative, anyone can file a patent. Now let's proceed towards the process of filing a patent. So first and very much important has to be innovative. You have to do lots of prior art search. Prior art search means you have to go to the patent site and you have to see whether your idea is not been already existing one. Then you have to check for various journals which is being published by the Indian Patent Office, and then when you come across or when you realize that this has not been disclosed or this has not been done by any other person, then you can then you can take a chance of filing a patent or drafting a patent. So then the next process is, once your search or once you come up with that your idea is a novel one, and when you realize that your idea is an innovative one, then yes, you are very much 100%, you can go ahead and you can do the patent filing process. So the patent filing, it can be done into two forms, that is called as the provisional specification and the other is complete specification. See, every time it is not necessarily that you have to go for provisional specification. Provisional specification means that you have your idea that you have been invented, it is at the earlier stage, and suppose if you want to you just have to block the idea so that no one else can carry out its copy, and you just wanted to file this particular type of the idea, and then you can refine it, you can make it more user friendly, and you can take a period of say around 12 months, wherein you can refine your idea, make it more appropriate, and then come up with a complete specification. Okay, so therefore for filing a patent, you can file the patent into two forms, that is either provisional specification or complete specification. It is not necessarily that always you have to go for provisional specification. With what your idea is, if you have a specific flow chart, if your claims are also ready, idea is being there, it is not going to produce any harm to the society, to the environment, definitely you can put forth the different claims, you can carry out the particular type of a design of an idea, and you can go for carrying out the process of filing a patent. So therefore, the two differentiating points that we have seen, that either you can go for provisional specification or you can go for complete specification. If you have already done with everything, you can go for complete specification. There is no need for provisional specification, right? So what is to be mentioned in this complete specification process? So of course, the title of the invention should be there, the field of invention, that is in what field your invention is based on, whether it is a technology related, science related, or whether it is artistic related, that you need to put forth for. Then you have to give the background of your invention. Background means like in case of research, the topic, the word that we use, rationale tells us about how important your idea is all about, and this idea is not being claimed by any other person initially. Okay, so by your prior art search, you will come to know that this is a novel idea. It is not being put forth by any other person. So you can make a very nice background specification, and based on this particular background concept, you can say that yes, your idea is a novel one. Then again, you have to give a detailed description of your invention. Suppose if your invention in the form of an experiment, then you have to write it down, the protocols or the steps. Of course, you don't have to disclose the each and every specification of your experimentation. Okay, because your patent is just in the process of filed version. It is not in the version of granted, right? So you just have to give a specification in the form of the flow chart or the protocol, but not a detailed one. If it is a drawing, then you have to go for giving a particular drawing of your invention. Then there should be an abstract, and of course, the process of patent filing, it can be done. So there are different forms which you have to go through. That is form number 1 for granting the patent in the form of, then form number 2, if your patent is in the form of a provisional specification. Then you have to go for filling form number 3, that is a statement of undertaking. Then declaration, form number 5, 8, 18, 26, 9. It's all related to authorization, request of early publication, request for examination, and so on. Then it's like a scenario that once we file a patent, we have to actually, people think that once the patent it has been filed, never knows it when it can be granted, right? Sometimes if generally there is a lag period of 12 months during which The process of examination, reviewing, it will be open to the public domain. Again, if suppose anyone wants to carry out any opposition, they can put a claim for. You have to carry out again rectification, clearing clearing the opposition which has been laid by the other party. And if you go through all this particular thing, your patent, it can be granted within 2 to 3 years of duration. So that means it has to be a work of patience. It is not like that ki once you filed a patent, immediately after 2 to 3 months, like you normally do for your research paper, your patent will be granted. So it is a slow process. It is going to take months. For initial process of examination, it is usually a period of 6 months. Then again, if the patent becomes open to the public, anyone can carry out opposition based on that. You have to put forth your claims, giving conclusive results that the objections raised by the other persons are false one. And then again the patent, then finally it comes into the stage of granting. So usually the tenure for granting the patent, it can be from extended from 6 months to 2 years. Now there are various fees. Every step you have to pay for the fees. For example, for the process of filing the patent also, there are charges which are being laid by the government authorities. It depends upon the number of the pages. So suppose your number of the pages are 30, then the charges are for individuals, it is 1,000 and so on. So this is how actually the patent charges go ahead. At every step, you have to pay. So if you want the examination of the patent to happen earlier, you have to pay 2,500. If you want the patent to be early published, then again you have to pay for 2,500 again. And once the patent it is granted, then also after 20, then after every year you have to pay additional fees of 500, 1,500 and so on. So this was all about the gist of my presentation, wherein I had put forth the intellectual properties and I basically focused on the patent filing process, the various offices of patents which have been present in different localities and so on. So this is how the IP it describes all about. So this form of the design of a chappal, it is a trade. It comes under geographical indication. The logo, it comes under trademark. The design, then the recipe, it comes under industrial secret, that is trade secret, and the overall formulations, it come under patent. Now, to talk about the patent which I was granted with, it is a design patent. So patent is basically divided into utility patents and design patent. Design patent means it is just a patent of that means the design which you have formulated, it is just not in the form of a working base. Still you have to go for out the experimentation so that the design it can be implemented into working form. This is a part of my PhD research process. As I've said, I belong to the faculty of microbiology, and my research was based on anti-cancer enzymes. Now we all are aware that cancer is the leading cause of death, and many of because of the climatic conditions, because of the food that we intake, a lot amount of people are getting affected with cancer every now and then. So there's the need, the chemotherapy that we already have, it has a lot amount of side effects. So therefore, the research of my PhD was to formulate or to come up with an enzyme which is isolated or extracted from microorganisms, which can specifically kill the cancer cells, and it will not kill any other normal cells. So if this target oriented therapy it has been planned, okay, this will create least amount of side effects and it will be benefit to the mankind. So my research was basically focused on isolating an enzyme from the enzyme, which is a biocatalyst. Like in chemistry, we have the catalyst, which speed ups the chemical reaction. Similarly, in case of microorganisms and living species, we have enzymes, which act as a form of a biocatalyst. And this biocatalyst, it has been helpful for converting the reactions and converting the raw materials into the product form. So this enzyme is basically focuses on an amino acid L-aspargine, And this L-aspargine, because of the presence of this L-asparginase enzyme, L-aspargine amino acid is converted to aspartic acid and ammonia. And this aspartic acid, it is present in huge amount in the cancerous cell. So therefore, my design patent, it was based on making a wall of which has this immobilized enzyme onto it, so that if we inoculate the blood sample, if we inoculate the patient's blood sample, we will be able to guess around ki is there any conversion happening, and if there is any conversion, we will be able to preliminary diagnose the early stages of cancer. So this was the patent which I was being granted 2-3 months back only. So it was based on my research topic. One more patent was being granted to me, and this was being based on the crop protection based scenario. Now we all know that um, there are so many barrenity which has been happening. That means the soil is not being converting into a productive form, right? Because of the extensive use of chemical fertilizers. So there's a need to shift from chemical fertilizers to biofertilizers. That is by making use of microorganisms. I know you people are from the field of chemistry, and I'm talking against your field, but basically, as I'm from biology, I'll be highlighting my field to be more eco-friendly than yours one. And I am sorry for that. So biofertilizers are the one which will increase the productivity of the crop, and on the earlier basis you can go for carrying out the detection of this particular crop diseases by making use of this particular biofertilizer. So that's all from my side of you. Thank you to the organizers. Thank you for everyone for patient listening. And I'm here to answer your questions if you have any. I hope this topic was been informative to all of you. And you must have gained some insights related to it. So thank you from my side.
Thank you, Nilima.
Thank you, ma'am.
Any questions? Ma'am, can you say a few more about the production of biofertilizer?
Okay. Biofertilizers basically are the one wherein we isolate different types of organisms. Okay, organisms, living species. We all are aware of various diseases, typhoid, malaria. They are all caused because of microorganisms. But it is nothing like that. Ki organisms are always harmful to the mankind. Organisms are also important for human beings. Also, we use lot many organisms in the field of fermentation. The idli batter that we normally get, it is because of the activity of the organisms which is happening, right? So organisms can be also used for increasing the fertility of the soil. They have an ability for mobilizing phosphorus. They have an ability of mobilizing or fixing nitrogen and making it available to the plants. And therefore, by making this availability of this micronutrients, the fertility of the plant, it can be increased to greater extent. Now, there are certain microorganisms which can withstand the high salinity of the soil, and at this high saline conditions also, where other things do not carry out this effect on, the microorganisms can mobilize and make these nutrients available to the plant, and you can also carry out the increase in fertility of the soil in such salinity related soil forms also.
Okay, ma'am, thank you. Any more questions? Okay, thank you for your insightful lecture on patents, ma'am. It was incredibly insightful and has broadened our understanding of intellectual property. Thank you, ma'am.
Thank you very much. Thank you.
കാത്തിടൂ കാവലാളായി കാത്തിടും